Hi guys, welcome back to another live video at Pratham Test Prep. This is your host Sanjeet Bhatia again, and today we'll be discussing some of the cases that are important for CLAT and AILET. As you all know, I'm a graduate from National Law University Bhopal, and I have taken multiple sessions on the channel. You can refer to all of them if you are preparing for CLAT and AILET, right? If you are aiming for CLAT 2021 or AILET 2021, these are some more cases that you can look into, right? From past 3 weeks, I've been covering all these cases, right? So you can have a look and see if you find them important. They might be of a lot of interpretative value to you once you're going for the exams. So if you haven't hit the like button yet, please do that, right? And if you haven't subscribed to our channel, definitely go ahead and subscribe to our channel also. Now, if you are not a part of our Telegram channel, I have said this time and again, if you're not a part of Telegram channel, do join our Telegram channel. You'll get the updates for last 1.5, 2 years, right? You have practice questions that you can go ahead and definitely solve. It is something that is available for free. You don't have to pay anything for it. It is just a normal subscribe button, and you can start on with all the preparation strategies that you require for your CLAT and AILET, right? I hope everybody goes and just subscribe to this channel, and you'll get the guidance from the graduates from top national law universities. Now, if someone is planning to join up for a course and haven't started yet, we are starting a new batches from 5th of June. You can definitely give us a call and enroll yourself and start with the preparation as soon as possible, because the time is out. The 12th boards have been cancelled. That's the news that has come up yesterday. The boards have been cancelled. So if you are planning to prepare, you can go ahead and prepare. The next part is the cases for the day, right? So starting from the first case of the day is Krishna Lal Chawla versus State of UP. This was the case that has come up against the frivolous legal matters that are being filed in the court. Right now, here the division bench of Mr. Mohan Shantan Godar and R. Subhash Reddy addressed that they were dealing with vexatious complaints. That is the word that they've used, which basically means annoyance, or which is against, or which is frivolous or wrong in nature or malified in intention, right? They have said that such complaints should be scrutinized in the initiation when they have been started, right? It is the duty of the trial court judge under the Constitution and the CRPC to identify and dispose of such matters, right? That was being held in this case of in Krishna Lal Chawla versus State of UP, right? This is the first case of the day. You don't have to learn these cases. You have to just understand what is the judge saying, what is being held, is it being overruled, things of that sort. And you have to just understand the interpretation that exists in these cases, right? If you try to learn the names, you are on the wrong track. Don't try to learn any of these names. Just try to understand what has happened in the case, what has the court said, what is the right interpretation to it. That's it. Because in the exam, no one is going to ask you what is this paragraph, which case is this, right? No one is going to ask you questions of that sort, right? So you can definitely understand these cases, get to the interpretation, get to the point where you are able to understand the legal jargon of these cases, right? What is the legal jargon of this case? Right, that it is, now you know that under the constitution and the CRPC, it is the duty of a trial judge to identify and dispose of such frivolous litigation at an early stage, right? And what are they exercising? The substantial and the fullest extent to the powers that they have with them, right? So the judge has the power where they can exercise this, and they can identify these frivolous complaints and just dispose of such matters, right? So when a judge sets aside a matter, it is also called disposing of the matter, or they say that whatever the order is passed against the judge case which is in the matter, right? So that is what you have to remember in such cases, that the judges were against the frivolous complaints. Now coming to the next case of the day, it is Rajat Sharma versus Union of India. This was a case that was done against the former JNK Chief Minister, Mr. Farooq Abdullah, right? Again, under the article that he wrote for Article 370, which was passed by the government, which was removed, right? Repealed, which gave a special status to JNK, right? So it was a bench which was headed by Sanjay Kishan Kaul and Justice Hemant Gupta. Now what they put a 50,000 on the petitioner, right? So this was the cost. It is called the cost, right? It is the punishment or penalty, you can say, which was put against the person who's put a petition in the court, or which is a public interest litigation, seeking to initiate proceedings against the former JNK Chief Minister, Mr. Farooq Abdullah, saying that he has given pro-China comments over the abrogation of the Article 370 of the Constitution. Okay. Now this was the case in hand. The petitioner filed this PIL where he said that he should be held, and the court said that a dissent from government's decision cannot be said to be seditious, right? Seditious means that you are inciting anything against the government. That is not happening. If you give a dissent, like you are not agreeing with the decision of the government, that cannot be said to be seditious. Now here, as it was held that it was a matter which wasted the court's time, right? They have also given a penalty to the petitioner, right? That is rupees 50,000, right? If you have filed such a case, you have to be punished, right? So they gave a fine of 50,000 in this case. I hope everybody is clear with the matter that was in hand, and the name of the case was Rajat Sharma versus Union of India. Coming to the next case of the day is Patricia Mukhim versus State of Meghalaya. I have discussed this case earlier also. Right now, here what was happening is that Patricia Mukhim was a reporter, right, with a newspaper in Shillong, right? So he was being punished for the matter. Now, what happened in this case is that, okay, Chanika, which case are you referring to? Kindly write that in the chat so that I know which case are you talking about. Okay, so in this Patricia Mukhim versus State of Meghalaya, what was the matter was that there was a case that was filed against Mr. Patricia for, okay, which was filed against Patricia for giving seditious comments out in the newspaper and inciting the local people out there, right? And they were filed in the sections of section 153 A, 500 and 505 1C of the Indian Penal Code of 1860. Now, the court said that freedom of speech of the citizen of a country cannot be stifled by implicating them in a criminal case. So they were trying to implicate this person just for writing their views, and their freedom of speech were being stifled by these criminal cases. Now, I will even explain you what were being said in these provisions that they were held in, right? So Miss Patricia Mukhim was held in section 153A, 500 and 5051C. So I will even tell you these sections so that you are aware about the interpretation of subsections and what are they saying. So you are aware about the law also, right? They might give you such sections in the in the paper also, so that you are able to understand what is being asked, what are the interpretation of such sections. Okay, starting from section 153A of the Indian Penal Code, right? When they say that promotion of enmity between different groups on the grounds of religion, race, place of birth, resident language, and doing acts prejudicial to the maintenance of harmony, right? If you are trying to create any sparks between different groups of people on the grounds of religion, race, or place of birth or residence, then if you are against the maintenance of harmony, you don't want harmony in the states, and you're inciting such emotions in the people of different groups, that is being charged under section 153A. Next is section 500, which is punishment for defamation. It tells you about what is defamation. When something is being said against a person, which is, if it's concluded to be untrue, then the person can be held for defamation, and the imprisonment of the term of 2 years or fine, or both, can be given to the person. So it defines the punishment for defamation under section 500 of the Indian Penal Code. Now, what does section 501C has to say? Now, this is something related to public mischief, right? Statements that are conducted to public mischief. The first part of the section talks about whoever makes or publishes or circulates any statements or reports, right? So this is basically on the circulation of reports or publications. Now, what is the part C talks about? With the intent to incite, or which is likely to incite any class or community of persons, right? Any person, any class of people who are getting incited to commit any offense and towards any other class, right? So basically, if you're trying to create any distress between two communities with your publication or circulation of any rumor or report, then it can be held under section 5051C. So that's how a person is being booked again in different crimes. जब आप सुनते हैं न्यूज़पेपर में कि उसके ऊपर ये धारा लगाई, so that is the meaning of that, right? That the person is being held under these sections. So these are the sections that are being defined. Now you can understand how detailed a criminal charge sheet would be, right? If a person is being incriminated, what kind of implications that a person can be put through. There are multiple sections which have multiple interpretations. So to book someone under the Indian Penal Code and put them into a state where they're not able to defend themselves also, and they have to prove a very big point to come ahead with that, then these sections get very complicated, right? So you can see that that's why the court has said freedom of speech of a citizen of this country cannot be stifled by implicating them in criminal cases, that because they are putting so many criminal charges against the person, they are trying to take this freedom of speech and expression, right? So you can see that what all a person, if you write one article which says about your own opinions about the working of a government or any other organization, and they come up with a case and just file you, just book you under these 3 sections, you can see how heavy it gets, right? So that's why the court took the side of Ms. Patricia Mukhim and said that it is a freedom of speech and they cannot book people under such sections because they are using their freedom of speech and expression, right? Because it is a fundamental right. Now, coming to the next case of the day, that is State of Goa versus Fauria Imtiar Shaikh, right? Now, here what is being in question is the election of the panchayats, right? Article 243K talks about elections of panchayats. Now, what is the point that is being called up here? Right now, the government officials who are being appointed as election commissioners are a mockery of the constitutional mandate, right? If the PM becomes the head of election commission, think of that sort, right? Think it that way, right? If the person who is in the power, who is fighting for the power, or who is working with the people in the power cannot become the official of the election commission, obviously it is a mockery of the constitutional mandate. Now, here, what was being called was the appointment of the Law Secretary of Government of Goa, a member of the IAS Society, as the State Election Commissioner. right? This was held by 3-judge bench of R.F. Nariman, Mr. Justice R.F. Nariman, Justice B.R. Gawai, and Justice Rishikesh Rao. Now, it was held that the appointment of these officers directly under the control of the state government is subversion of the constitutional mandate, right? So the constitutional mandate provides, the Article 243K provides the person who's the election commissioner to have a fair, just, and unbiased opinion, and things of that sort are being mentioned in Article 243K, and the mandates that are being given to a person who's heading these elections and the election commission of the state. Now, if the person is belonging to the state government, it creates, the person is a judge of his own case. You can see that it can be said that the person is being called as the judge of his own case, and he can be biased in such situations. That's why it is saying that if someone is being appointed, it is the subversion of the constitutional mandate that is being contained in Article 243K of the Constitution of India, right? So that is what was being held, right? If you are working with the government, you cannot be given such a position. It will be called a mockery of the constitutional mandate. Now, Anshita asked me, sir, do we have to learn these cases names? I have told you, Anshita, you don't have to learn the names of these cases. You can just definitely understand what is being said, how are they being interpreted. You don't have to learn the name of these cases. I have said time and again, no one is going to ask you the names of these cases. It is exactly useless to learn the names. Just understand the interpretation, what is being said in the case, what were the facts. If you're able to understand the facts and the interpretation of the laws that were being used in the case, then you are absolutely good to go. You don't have to learn these cases. Chanika, I will take your doubt towards the end, but if you are not able to understand Rajesh Sharma versus Union of India, you have to understand there was a case filed against Mr. Farooq Abdullah under a public interest litigation, right? The person who filed the case was fined with rupees 50,000, right? Because it was held that a person who's giving a dissent or who's not accepting the decisions that are taken by the government, it cannot be said to be seditious, right? It is not seditious in nature. So there was a penalty of 50,000 that was put on the petitioner for putting up such a case against the former Chief Minister, Mr. Farooq Abdullah. I hope you are able to understand it in short and crisp that that was the case that is being held in the court. Coming to the next part is that the democratic reforms versus Union of India, right? There was said that there is no interference with the scheme of the sale of electoral bonds. Now here what is being said that the 3-judge bench of Justice S.A. Bobde, who was the former CJ, A.S. Bopanna, and Mr. V. Ram Subramaniam refused to interfere where the scheme of sale of electoral bonds by the political party, right? Now here it was being said that the political parties will not declare, they will keep the anonymity of these people who have bought those electoral bonds, right? And said that it was held that it is not healthy for the democracy. But the court did not say the same. The court said that even though scheme provides for anonymity, it is intended to ensure that everything happens only through the banking channels. Right, so they are saying that one way, they are stopping us from getting the information, but they are taking the right channels for doing the same. Now you can see it is a very confusing state of affairs for the country, right? One time, like if you see it in a way, the political party can sell their electoral bonds to whoever they want. They don't have to declare. They can keep the anonymity of the person, right? People said it is not healthy for the democracy, but the court has a different view. They said that if it is through the right banking channels, then it is fine. They can say that everything happens only through through right banking channels. So it is perfect for them. Okay, so it is on you to decide, right? These are the cases. You will find a lot of contradicting things that are being said by the court, but you have to see that it depends on the bench of judges who are there on the order side, who are ordering for the case, So there will be different like opinions that will come up and different decisions that will come up. As we have discussed last time also, there was a case that was happening for live-in relationships in Court of Punjab and Haryana. There were two different benches who gave like two different opinions on the same. One said that it is against the social strata, and the other said that yes, they have to be protected, but right, because there was a female judge on the side, so she talked in a different manner, and there were a male judge on the other side, so there was a different opinion that was being presented in the case. So that is also happening in this. You have to see that different judges on different benches will give different kinds of decisions. Coming to the next case is Cutis Biotech versus Serum Institute of India. Right, the Cutis Biotech filed a petition in the Maharashtra court in Pune, where their petition was rejected because they were claiming the trademark of the word Covishield for their COVID-19 vaccine. Now it was said that they want to restrain Serum Institute of India from using the trademark Covishield or for any of their products that are being taken out in the for COVID-19 vaccines, right? And said that the firm has used the name prior to Serum Institute of India. So this was rejected in the civil court in Pune, right? There was an injunction that was being applied by the Cutis Biotech for the name Covishield, right? Trademark is basically the mark that has to be used by a company for selling their products. If you have seen, there is always a small TM that is written over a lot of products that you buy around. Right, so that TM means trademark, that only that company can use that particular mark to sell its products. Right, so that is what is trademark, and here the petition of Cutis Biotech was being rejected. Coming to the next set of cases is the first is where there is Sravnan versus state. Here the condition of deposit of bail amount, right, while granting bail. Okay, so there is small amount that has to be deposited by a person while they are getting a bail. Now, it was held that while granting such bail under the section 167 part 2 of the CRPC, condition of deposit of amount cannot be imposed. Right, it is not important that the condition for deposit of such amount can be imposed. So you can, this is small facts for you. You can look at it. You don't need to learn. Just look at it and move ahead. This is just for improving your legal knowledge and you to understand what does all these things means. Now, second is Mr. Naresh Kumar Mangla versus Anita Agarwal. There is no embargo on the transfer and investigation to the CBI. They said that the case can be transferred to CBI and investigation can be given after the submission of the charge sheet, right? There is no embargo then when it can be transferred to CBI. After the submission of charge sheet, it can be given to the CBI. Once, and charge sheet is the list of charges that is being taken against a person who has committed a crime, right? So FIR, then there is a charge sheet that is being filed in the court saying that under what charges the person is being held, and that is being given to the court. Then court decides on the matter, are these criminal cases also valid or not, right? So I hope everybody is clear on that part again. Coming to the last set of cases is Saurav Yadav and others versus state of Uttar Pradesh. Now it talks about the candidates that are belonging to the reserve category are eligible to file under the general and open categories also based on merit. Right, so that was the case that was being held. That is the last case of the day that we have discussed. You can see that what was held. Now there can be a factual scenario that can come up on this case, but now you know that what is the basic thing that is being said in the case, because I've told you in brief. Right, it was, if they give you a case regarding a person who was belonging to some category, then he tried to go for a seat in the general category or the open category, right, but was claiming the quota. Right, now what will you do in such case? There can be a factual scenario on that matter. Can he get the seat in general category or he has to go through the quota only? Right, so things of that sort can be asked. So you can keep these things in mind and go ahead with your preparation. I hope Everybody is clear with all the cases that we have discussed. We have discussed at least 10 cases for today, for this session, which is good enough for the day, that if you are able to understand the interpretation of these 10 cases, you are good to go ahead, right? So that is it. If you are interested for any counseling or mentorship with us, you can definitely keep a screenshot of this number. You can give us a call. We'll be happy to help you all for any exam preparation that you are looking forward to, right? That can be any exam related to management, law, psychology. If you are planning to travel abroad to study, you can definitely give us a call. We'll provide you with international assistance also. That is also something that you can definitely come ahead with. Okay, so these are the things for today. Okay, so Chanika wants to see the slide of the last case. You can go ahead, right? It is Saurav Yadav and others versus State of Uttar Pradesh. So you can keep a screenshot, Chanika, for the same, and go ahead with reading the case ahead. Now, that is it for today. I hope everyone is safe, stay healthy, use your hand sanitizer, wear a mask, wash your hands properly, maintain social distancing. And if you are above the age of 18, definitely go on for vaccinations, right? If you are not above the age of 18, you can definitely tell people who are around you above the age of 18 to go for vaccine. You can read about it and definitely help these people to go ahead and get vaccinated. If they're not able to book slots, definitely help people out, right? Thank you all. Hope to see you on Friday again with an interesting session. I have decided the name of the session. You'll definitely see it well scheduled in our channel. So definitely subscribe to it, hit the like button, and hope to see you soon all again.